welcome to 5-Minute Family Law. Today's episode is all about getting divorced. Now, I've already covered the basics of getting divorced in a previous episode, episode 3. So what I'm going to do today is I'm going to provide a brief overview of the divorce process, and then we're going to get into the more technical details about when the court has jurisdiction to hear a divorce claim, the ground of divorce and how you're going to be able to prove the ground of divorce, and the reasons why the court won't give you a divorce order. The only way that valid marriages end in Canada, other than through the death of one of the spouses, is through a divorce. A divorce is a court order, and in order to get that court order, you have to start a lawsuit, even if both spouses agree that they ought to get divorced. In British Columbia, a claim for a divorce order is begun by filing a notice of family claim in the British Columbia Supreme Court. Under Section 3 of the Divorce Act, however, there are some limits on when and how that claim can be started. Section 3 says that a court in a province has jurisdiction to hear and determine a divorce proceeding if either spouse has been habitually resident in the province for at least 1 year immediately preceding the commencement of the proceeding. What that means is that you have to have lived in the province whose courts you're asking to make the divorce order for at least 1 year before you ask for the order. Now, you can start the claim for the divorce ahead of that. You just can't get to the spot where you're actually asking the court to grant the divorce until you've been there for a year. Now, if you and your spouse are living still in the same province where you've always lived, that's not a problem. You can just simply file for a divorce. But let's say that you moved to British Columbia from Alberta only 3 months ago. Well, because you haven't lived here for the full year, you're going to have to wait another 9 months until you can ask the court for the divorce order. You can start the claim for the divorce now, but you can't actually get around to asking for the divorce order until another 9 months have passed. On the other hand, if your spouse still lives in Alberta where you came from, well, as long as your spouse has lived there for at least 1 year, then you can start your claim in Alberta. There is only one reason or ground why the court will make a divorce order. That is, proof that your marriage has broken down. There are, however, 3 ways that you can prove that your marriage has broken down. First, that you and your spouse have lived separate and apart for at least 1 year. Second, that your spouse has committed adultery. And third, that your spouse has treated you with such mental or physical cruelty that you could no longer continue to live together. Now, that all actually sounds rather easy, and in fact it is, particularly with respect to separation, because quite frankly the court doesn't inquire too closely into the accuracy of the dates that you've provided about when you married and when you separated and how long you've lived separate and apart. I'm not telling you to lie, of course, but this is the easiest way to get divorced. The advantage, so to speak, about divorces based on adultery or cruelty is that you don't have to wait that full year. You can begin the claim for the divorce and ask for the divorce order pretty much right away. However, adultery and cruelty are a little bit more complicated because the court will inquire into the adequacy of the proof that you've presented. So let's talk about adultery first. The idea with adultery is that your spouse has had sex with someone who is not you. You cannot ask for a divorce based on your own adultery. It has to be your spouse's adultery, and on top of that, you can't have forgiven your spouse for their adultery. If the court believes that you've forgiven your spouse and resumed married life, it won't give you a divorce order because it won't believe that your marriage has in fact broken down. But assuming, however, that you haven't forgiven your ex, you then have to get around to actually proving that the adultery occurred. And the kind of proof you need is objective proof. It can't be the kind of proof that requires the court to draw an inference. For example, a hotel receipt that you found in your ex's wallet might lead you to believe that your ex committed adultery, but it's not necessarily proof that the court is going to accept because your ex could have been going to the hotel for a number of reasons. So in the old days, we used to prove adultery through photographs, usually taken by a private investigator. These days, I assume that the photographs are most easily found on your ex's phone or on your ex's social media accounts. But you need to have that kind of objective proof that the adultery occurred. The easier way to get proof of adultery is, quite frankly, to get an affidavit from your spouse in which your spouse admits to the adultery. Cruelty works in pretty much the same way. First of all, it has to be your spouse's cruelty towards you, which is leading you to ask for the divorce order, not your cruelty to your spouse. Secondly, you can't have forgiven your spouse because, again, if you've forgiven your spouse and resumed married life, the court will not reach the conclusion that your marriage has in fact broken down. And thirdly, you still need that kind of objective evidence from someone who is not you that the cruelty happened. So normally the evidence that we provide to the court would take the form of an ER report, a report from your doctor, a letter from your clinical counselor or psychologist, or something like that. But the court requires objective proof of the cruelty or it won't grant the divorce order. The other reason why divorce applications based on cruelty or adultery can sometimes be a little more complicated is that in the affidavit that you provide the court when you're asking for the divorce order, you are going to have to say that you did not connive with your spouse towards the ground of marriage breakdown and that you're not part of a conspiracy towards the ground of marriage breakdown. Now, this isn't very complicated because this text is all part of the court form that you're going to be asked to fill out. However, I should explain what connivance and conspiracy are just to make sure that you can avoid stepping accidentally into any traps. So the idea with connivance is that you and your spouse worked at a deal to arrange the facts that are necessary to prove the reason for marriage breakdown, such as talking to your spouse and saying, look, why don't you go and have sex with the neighbor and then we'll make a claim for divorce based on adultery. Or conspiracy would be you working with the neighbor, please seduce my spouse so that way I can get a divorce based on adultery. And what this all boils down to is the idea that the facts that support your claim for divorce on the basis that your marriage is broken down as a result of adultery or cruelty have to have happened on their own. There can't be something that you have organized. Finally, the court may also refuse to grant you a divorce if it is not satisfied that the right amount of child support is being paid. Now, obviously, this is only a factor if there are children who are entitled to receive child support at the time you're asking for the divorce order. And if that is the case, what will happen is that in your affidavit, the affidavit that you file to ask for the divorce order, you're going to have to provide some additional information about your income, your spouse's income, the number of children who are entitled to receive support, and the province or territory in which the payor lives. Section 11 of the Divorce Act says this: in a divorce proceeding, it is the duty of the court to satisfy itself that reasonable arrangements have been made for the support of any children of the marriage, having regard to the applicable guidelines, and if such arrangements have not been made, then to stay the granting of the divorce until such time as they have been made. And so, reasonable arrangements in that section refers to the child support guidelines and whether the right amount of child support is being paid according to the number of children, the payor's income, and the province or territory in which the payor lives. And as long as that amount of support is being paid, everything will be fine. However, if a different amount of support is being paid, you're going to have to go through some extra hoops and provide additional information in your affidavit to prove that reasonable arrangements have been made. And so, under the child support guidelines, reasons why a different amount than the table amount might be paid include because you and your spouse share the children's time equally or almost equally, because one or more of the children are older than the age of majority, because the payor is a step parent of the children for whom support is being paid, or because the payor earns more than $150,000 per year. And so if any one of those things are resulting in in an agreement or an order that a different amount of support is going to be paid, you're going to have to explain that in the affidavit, and the court is still going to have to exercise its judgment and be satisfied that the arrangements you've made are, in fact, reasonable. And so those are some of the more technical details about getting divorced in British Columbia. In addition to this episode, you should also check out episode 3 about the basics of getting divorced, as well as the bonus content video that talks about the desk order divorce process. The desk order divorce process is a special process developed by the court to allow you to get divorced without ever having to appear in front of a judge. However, it can be a little complicated, and the court is extremely fussy about the paperwork, which may result in you getting your divorce application tossed even before it lands on the desk of a judge. So check out that video, check out episode 3, and you ought to be able to get divorced all on your own without ever having to hire a lawyer.